So, you're here, no doubt, because you've gotten one of these. Failure to pay rent, landlord's complaint. Simply put, this means that the landlord is asking the judge to evict you because you didn't pay the rent on time. Make sure to get to court on time and bring your court notice. If you are late, you may lose your chance to defend yourself. First, check the court docket for the list of cases to be heard today. They're listed alphabetically by address, not by name. The landlords, their agents, or attorneys are often in the hallway before court begins. Even if you haven't paid your rent for whatever reason, consider speaking with the landlord to see if you can either resolve the problem or agree on a settlement. But do not leave. Do not allow the agent to handle the case without you. The only person that can assure that you receive a fair hearing where your side of the story is heard is you. Do not leave without the judge hearing your case. If you do make an agreement with the landlord, make sure to get a receipt for any money that you pay and stay in court so that you and the landlord can tell the judge about the agreement that was made. This is for your protection as well as for the landlord. When you come into court, check in with the clerk so that they know you're present. Once your case is called by the clerk, go to the table on your left. The table on the right is for the landlord or agent. From here on out, the only person you should address is the judge.
All rise. The District Court of Maryland is now in session. The Honorable Judge Batson presiding.
Thank you. Would everyone who will be testifying as a witness today, including the landlords and tenants, please remain standing. Raise your right hand to be sworn in.
Do you solemnly declare or affirm on the penalties of perjury that the statements made and the responses given will be the truth and nothing but the truth?
Yes. Please be seated.
Case number 865-375, 2008, 4203 Chestnut Avenue.
Do you represent the landlord?
Yes, I am Samantha Burton, agent for Smith Properties.
Is the tenant, Ms. Alberts, present? The tenant has failed to appear. The court rules in favor of the landlord for $980 plus late fees, as stated in the complaint, and grants possession to the landlord.
Case number 865-107, 2008, 7205 Utah Street.
Are you Teresa Jones?
Yes.
We've reached an agreement, Your Honor.
Please state the terms of the settlement for the record.
Tenant agrees to pay $300 to the landlord in rent and court fees, and the landlord agrees to dismiss the case. Payment was made this morning.
Do you agree with the settlement?
Yes, Your Honor.
Very well. Case dismissed.
So here's what just happened. Teresa showed up to court, found the landlord's agent, and they made an agreement as to how much money she would pay to have the case dismissed. She made the payment before court began, got a receipt, and then stayed to make sure that everything went according to the agreement. You see, the burden of proof lies on the landlord. That means that the landlord has to prove to the court that they own the property, that it was rented to the tenant, and that the tenant didn't pay the rent on time. The landlord writes all of this in the complaint and swears it is true under oath. If you are not there to tell your side of the story, no one is going to do it for you. Any of the other cases that were heard where the tenant did not show up are automatically granted to the landlord. The landlord's burden of proof was met, and the court granted a judgment for possession. Before we go any further, let's review some details. Make sure to come to court and be on time, or you will lose your right to defend yourself. Check the docket to find your case. It will be listed by your address and the case number. Talk to the landlord or landlord's agent before court. Try to come to an agreement to dismiss the eviction case. Get a receipt for any money paid. Then, stay in court to make sure your case is heard by the judge and any agreement is stated correctly. If you don't agree with the landlord and cannot come to an agreement, tell the judge your case and then listen to the judge's decision carefully.
Mr. Plimpton, the complaint states that the tenant owes $75 in rent. Is that right?
That's correct, Your Honor.
Mr. Jones, do you owe rent in the amount of $75?
Yeah, but
The court rules in favor of the landlord. $75 plus court fees.
If you have a defense or don't agree with the charges, say so.
Mr. Jones, do you owe rent in the amount of $75?
I don't agree with the landlord, Your Honor.
Go ahead.
The $75 is not part of my rent. It's a citation that the landlord received because the trash area isn't
It's
large
not
enough.
the point, Marcus. You didn't put your trash in the right place.
There was nowhere else to put it. The trash room is not large enough for
You will
everybody.
be respectful in this court. Please address your comments to the court, not to each other. If you were asking the court to authorize an eviction for non-payment of rent, can you prove that the amount of rent that the tenant owes is classified as rent under the law and that the lease defines it as rent?
I have the lease right here, Your Honor.
After reviewing the lease, I find that the citation isn't classified as rent, and the citation is not rent under the law in any event. The citation, therefore, cannot be collected in this court. The court rules in favor of the tenant. Case dismissed. Mr. Jones, you're free to go.
The rental agreement is what tells both landlords and tenants how they're supposed to deal with each other. A rental agreement may be a written lease agreement like the one Marcus had, but an oral month-to-month agreement is a valid rental agreement as well. Let the court know you have a defense. In court, speak only to the judge, not the landlord. Bring any evidence you have to court, such as leases, rent receipts, or letters or notices to or from the landlord. Remember, to evict you for non-payment of rent, the landlord must prove that what you owe is actually considered rent under the law. Rent is the payment you make to the landlord for use and occupancy of the property. Some charges, such as utilities paid for by the tenant, may be considered rent if they are included as additional rent in the lease. Items that are not considered rent include charges for citations or fines against the landlord, even if you, the tenant, caused them. Charges for maintenance, repairs, or damages also cannot be collected as rent, nor can security deposits. Your landlord may have the right to sue you in a separate case for these amounts, but cannot evict you through rent court for these because they are not considered rent.